What I see happening is this. I think that we are rethinking all of our major legal categories through the litmus of digital information. When I went to law school, intellectual property was copyright, trademark, patents, very discrete little boxes of information. Now when I teach contracts to first-year students, I still have them read the 19th century cases. You know, they're still reading Hadley versus Baxendale and Raffles v. Wickelhaus, these old, you know, classic cases. But we're also looking at online cases and digital cases. And I think it's changing the way we think about things. And I think it's going to realign a lot of the basic categories. Law faculties are incredibly tradition-bound. We're an apprentice system. How do you get to be a law professor? You're somebody's research assistant, you clerk for the right judge, then you mentor yourself to an older faculty person. It makes it very hard to change the model. And I think we don't even see how the change is happening. But it's all over the curriculum now, where the old ways of just classifying information are breaking down. One of the things I'm working on this summer is looking at some of this, because the same thing happened as West grew. When the West system came along, it allowed for a total rethinking of how you classify the information, because the information was available, it had these hooks, and you could see not what the law was 50 years ago, but what it is today. And I think that's going on right now. But we're in the middle of it, so you can't quite see what's going on. And if I talk to my colleagues about it, they'll disagree with me and say, no, you're nuts. But I don't think, you know, it's not like we can have a big meeting of all the law professors and judges and lawyers in the country and say, well, we're going to start thinking about things differently. It's got to ooze into it. But once you're there, then you'll say, well, of course.